The power of arrest and/or the power to arrest. This is the stuff that Lesson 3, Part 3, Subpart 1 is made of. Let's formally introduce the concept of arrest to the class. In Nigeria, the presence of an accused person in court for his trial can be compelled in any of the following ways. 1. Arrest without warrant. 2. Arrest with warrant. And 3. Summons. The law recognizes lawful arrests without law and also lawful arrests combined with a search of the person being arrested, a search of the things of the person being arrested, and a search of the premises or objects the arrested person is in at the time of his arrests. Studying law as if it were an abstract concept does not yield a lot of dividends, and that is why this lecture will analyze the following high-profile arrests with a view to determining how they measure up to the legal requirements for a lawful arrest. First, Omoyele Sowore's arrest within the premises of a hotel by the State Security Service, also known as SSS, on August 3, 2019. Second, Omoyele Sowore's arrest within the premises of the Federal High Court by the State Security Service on December 6, 2019. Third, Senator Shehu Sani's arrest by the Economic and Financial Crimes Commission, also known as the EFCC, for alleged fraud. Fourth, Nigerian actor Baba Suwe, whose real name is Babatunde Omidina's arrest by the National Drug Law Enforcement Agency, NDLEA, for allegedly ingesting hard drugs. Fifth, Ismaila Mustafa aka Momfa's arrest by the Economic and Financial Crimes Commission EFCC for allegedly committing fraud, money laundering, and running a foreign exchange business without the authorization of the Central Bank of Nigeria (CBN). Sixth, the arrest of Onari Taylor Harry, a Rivers State-based legal practitioner, by officers of the IGP stands for Inspector General of Police Monitoring Squad of the Nigeria Police Force, for issuing a quit notice to some tenants renting a house he is managing. Seventh, the arrest and detention of Chima Ikunadu and his apprentices Victor Ubona, Ozaze Friday, Ifeanyi Osuji, and Ifeanyi Onyekwere by police officers attached to the Mile 1 police station for allegedly driving against traffic. Eight, the arrest of the Nigerian husband of a Canadian lady, Colin Santos-Amalu, allegedly for sporting the wrong kind of haircut by some rogue policemen in Lagos. Ninth, the Economic and Financial Crimes Commission EFCC's raid of nightclubs around the country and the consequential arrest of patrons and persons found in the vicinity of those nightclubs. Tenth, the arrest and detention of a certain London-based businessman Chidera Ejiri and his cousins by some Nigerian soldiers attached to the 144 Nigerian Army Battalion, Osisioma, Abia State. 11th, the arrest of Mr. Chukwu Ebuka by the Economic and Financial Crimes Commission for publishing a picture it considers uncomplimentary. 12th, the arrest of Tiyaniyu Kazim, aka Kaka, by a team of officers of the Federal Special Anti-Robbery Squad, acronym led by the now dismissed officer Olaniyi Ogunsoro, aka Oyatu, at Orile Imo area along Shagamu-Abeokuta Expressway in Ogun State. This video will address just the first case study, Omoyele Sowore's arrest at his hotel accommodation by the State Security Service SSS on August 3, 2019 to set the tone for our treatment of the subject, the power of arrest and or the power to arrest under Nigerian criminal law. According to Sahara reporters, Omoyele Sowore, the presidential candidate of the African Action Congress, AAC, in the 2019 elections, activist and convener of Revolution Now protest, was picked up, that's another way of saying arrested, at his apartment in the early hours of Saturday, August 3, 2019 by operatives of the State Security Service. We have provided a link to a video of the entire arrest operation as captured by CCTV in the video description box below, for those of our viewers who may be interested in reviewing how the operation was conducted. This was a direct response of the government to his launching of his Revolution Now campaign on Twitter with a series of tweets mobilizing Nigerians for a protest march against bad governance in Nigeria, which he had scheduled for August 5, 2019. In defense of that arrest, President Muhammadu Buhari's aide on social media matters, Loretta Onochie, commended the operatives of the State Security Service for effecting his arrest. These were her exact words as captured from her Twitter account. This is what DSS saved Sowore from, referring to an image mashed up from 3 different pictures of a man engulfed in flames. He talks about setting himself ablaze. It is in order for the security operatives, whose role it is to safeguard both lives and properties, to take him into custody to prevent him from harming himself and get him the help he needs. The Nobel laureate Omoyele Sowore's response was condemnatory, for he said, "Beyond the word revolution, another much misused and misunderstood word, nothing that Sowore has uttered, written or advocated suggests that he is embarking on or urging the public to engage in a forceful overthrow of government." He went on to compare the actions of the SSS under President Muhammadu Buhari to the actions of security agencies under the late dictator Sani Abacha in the following words: "We underwent identical cynical contrivances under the late unlamented Sani Abacha when he sent stormtroopers to disrupt a planning session for a similar across-nation march at Tai Solarin School, Ikenne." We have provided a link to his full statement in the video description box below. Yet another defense of the government's actions came explicitly from presidential spokesman and senior special assistant media and publicity to Nigeria's executive president Garba Shehu, who said the Buhari administration respects the constitutional rights of citizens and the opposition to protest peacefully. But he hastened to clarify that Sowore was trying to do something different. Sowore is an opposition member who is seeking power through another means. We cannot say that this is about the media. The government has not prevented journalists from carrying out their assignments and duties. He continues that there is a difference between a peaceful call to protest and incitement for a revolution. The public relations officer of the agency that effected the arrest, that is the State Security Service, Peter Afunoya, in siding with the government story, stated why Sowore was arrested. If they are operating as a responsible security organization and someone is calling for revolution in Nigeria, we must understand the meaning of revolution. Primarily, it means a revolt. It means insurrection. It means insurgency. It means forceful takeover of government. And we are operating democratic system in Nigeria. Nigeria is not a banana republic and cannot suddenly be made one. So the DSS will not just sit by and watch individuals or groups wanting to rise and threaten the peace and unity of the country. We want to also reiterate that the plots by some self-seeking individuals and groups to cause a breakdown of law and order, cause disaffection, disrupt social and economic services will not be tolerated. Not everyone agrees with the government's line, though. Aneti Ewa, a Nigeria researcher Africa Division at Human Rights Watch, commenting on Sowore's arrests and media reports that the Nigerian government placed Amnesty International on security watch on August 1, 2019 for allegedly reproducing a message by the organizers of the Revolution Now protests in a tweet, observed, "If Omoyele Sowore has been arrested in an attempt to stop the protest he helped organize, that would be a damning indication of the government's increasing intolerance for critical voices. The mere use of the word revolution as a slogan is not enough to support a claim of violent insurgency and should not be treated as a crime. Nigerian authorities should end the harassment and intimidation of individuals and groups that legitimately criticize government actions and policies, including Amnesty International. Sowore and other detained protesters should either be charged within the constitutionally guaranteed 48-hour period or released unconditionally. Famous Nigerian human rights lawyer Femi Falana also lent his voice in support of Sowore when he requested that the Nigerian government tell him the section of the Nigerian constitution that finds Sowore guilty of treason. From the above snippets, there are basically two camps, those in favor of Sowore's arrest and those against Sowore's arrest. Who is right and who is wrong? Was Omoyele Sowore's call for nationwide protest on August 5, 2019, under the banner Revolution Now, an insurrection aimed at the forceful takeover of government and punishable upon conviction with life imprisonment, fine, or both? Was Omoyele Sowore's arrest by the operatives of the State Security Service justified in law? Was Omoyele Sowore's call for nationwide protest lawful by virtue of the fact that the right to peaceful protest is a fundamental human right guaranteed under both Nigerian and international law? Was the government being paranoid and thus overreacted? Or was it being proactive and thus acted justly in the circumstances? This lecture entitled The Power of Arrest and or The Power to Arrest under Nigerian Criminal Law is designed to empower you to answer those questions and understand the considerations that would influence Nigerian courts' determination of such matters. How does the Dictionary of Law define arrests, and what can we learn about arrests from an encyclopedia? Please stay tuned. The Oxford Dictionary of Law 7th edition defines arrests as follows: the apprehension of a person suspected of criminal activities. It continues, most arrests are made by police officers, although anybody may arrest. And on arrest, this is what Wikipedia has to say. An arrest is the act of apprehending a person and taking them into custody, usually because they have been suspected of committing a crime. After the person is taken into custody, they can be questioned further and or charged. An arrest is a procedure in a criminal justice system. Closely connected to arrest is the power to arrest or the power of arrest. On this too, let's turn once more to Wikipedia. The power of arrest is a mandate given by a central authority that allows an individual to remove a criminal's or suspected criminal's liberty. The power of arrest can also be used to protect a person or persons from harm or to protect damage to property. However, in many countries, a person also has powers of arrest under citizens' arrest or any person arrest or breach of the peace arrest powers. What constitutional provisions have a bearing on the subject of arrests? Section 33, subsection 1 states, every person has a right to life, and no one shall be deprived intentionally of his life, save in the execution of the sentence of a court in respect of a criminal offense of which he has been found guilty in Nigeria. Section 33, subsection 2 says, a person shall not be regarded as having been deprived of his life in contravention of this section if he dies as a result of the use to such extent and in such circumstances as are permitted by law of such force as is reasonably necessary in order to effect a lawful arrest or to prevent the escape of a person lawfully arrested. Section 35, subsection 1 states every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty save in the following cases and in accordance with the procedure permitted by law. In execution of the sentence or order of a court in respect of a criminal offense of which he has been found guilty, by reason of his failure to comply with the order of a court or in order to secure the fulfillment of any obligation imposed upon him by law, for the purpose of bringing him before a court in execution of the order of a court, or upon reasonable suspicion of his having committed a criminal offense, or to such extent as may be reasonably necessary to prevent his committing a criminal offense, provided that a person who is charged with an offense and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed for the offense. Any person who is arrested or detained shall have the right to remain silent, avoid answering any question until after consultation with a legal practitioner or any other person of his choice. Any person who is arrested or detained shall be informed in writing within 24 hours and in a language that he understands of the facts and grounds for his arrests or detention. Any person who is arrested or detained in accordance with subsection 1, subsection C of this section shall be brought before a court of law within a reasonable time, and if he is not tried within a period of 2 months from the date of his arrest or detention in the case of a person who is in custody or is not entitled to bail, or 3 months from the date of his arrest or detention in the case of a person who has been released on bail, he shall, without prejudice to any further proceedings that may be brought against him, be released either unconditionally or upon such conditions as are reasonably necessary to ensure that he appears for trial at a later date. In subsection 4 of this section, the expression "a reasonable time" means in the case of an arrest or detention in any place where there is a court of competent jurisdiction within a radius of 40 kilometers, a period of 1 day, and in any other case a period of 2 days or such longer period as in the circumstances may be considered by the court to be reasonable. Any person who is unlawfully arrested or detained shall be entitled to compensation and public apology from the appropriate authority or person. And in this section, the appropriate authority or person means an authority or person specified by law. Nothing in this section shall be construed in relation to subsection 4 of this section as applying in the case of a person arrested or detained upon reasonable suspicion of having committed a capital offense, and as invalidating any law by reason only that it authorizes the detention for a period not exceeding 3 months of a member of the Armed Forces of the Federation or a member of the Nigerian Police Force in execution of a sentence imposed by an officer of the Armed Forces of the Federation or of the Nigerian Police Force in respect of an offense punishable by such detention of which he has been found guilty. Section 308, subsection 1, notwithstanding anything to the contrary in this Constitution, is subject to subsection 2 of this section. No civil or criminal proceedings shall be instituted or continued against the person to whom this section applies during his period of office. A person to whom this section applies shall not be arrested or imprisoned during that period, either in pursuance of the process of any court or otherwise. And no process of any court requiring or compelling the appearance of a person to whom this section applies shall be applied for or issued, provided that in ascertaining whether any period of limitation has expired for the purpose of any proceedings against the person to whom this section applies, no account shall be taken of his period of office. Section 308, subsection 2. The provisions of subsection 1 of this section shall not apply to civil proceedings against the person to whom this section applies in his official capacity, or to civil or criminal proceedings in which such a person is only a nominal party. What is the enabling provision for arrests under the ACJA? There you have it on the screen. Section 3 of the ACJA tells us that a suspect or defendant alleged or charged with committing an offense established by an act of the National Assembly shall be arrested, investigated, inquired into, tried, or dealt with according to the provisions of this act, except otherwise provided under this act. What is the enabling provision for arrests under the ACJL? Section 1 of the ACJL tells us, in making an arrest, the police officer or other person making the arrest shall touch or confine the body of the person to be arrested, unless there is a submission to the custody by word or action. Please take the time to compare Section 2 of the ACJL. What is the enabling provision for arrest under the CPA? Section 3 of the CPA tells us that in making an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested, unless there is a submission to the custody by word or action. What is the enabling provision for arrest under the CPC? Sadly, none. The CPC is silent on the power of arrest. Nigeria's legal system was largely borrowed from the British. That remains true till this day. How has the current Nigerian law on arrest diverged from the current British law on arrest? Let's take a few minutes to elaborate. Police constables, police community support officers, immigration officers, Her Majesty's Revenue and Customs, criminal investigation officers, prison officers, church wardens, court bailiffs, court officers, court security officers, sheriffs, sergeants at arms of the House of Commons, Environment Agency officers, water bailiffs, and Independent Police Complaints Commission investigators have the power to arrest in England and Wales. In addition to the above, UK law recognizes and permits citizen arrests, for it holds that any person can arrest anyone whom he has reasonable grounds for suspecting to be committing, have committed, or be guilty of committing an indictable offense, provided that certain conditions are met in advance of the arrest. The first condition is that the citizen attempting to effect the arrest must believe at the time of the arrest that it is not reasonably practical for a police officer to perform the arrests. This rule exists to ensure that the police remain the main law enforcement institution. Without this rule, the police would risk being undermined by allowing any individual to make arrests even when a police officer is present. Citizens should not have the same powers of arrest as the police. The second condition concerns the meaning of reasonable belief, which is mentioned often in the legal definition. The citizen must reasonably believe that the arrest is necessary to prevent one of the following. 1. The person causing injury to themselves or others. 2. The person suffering physical injury. 3. The person causing loss or damage of property. 4. The person escaping before a police officer can assume responsibility for them. In terms of what will be viewed as reasonable, the decision will be made on an objective basis. This means that the citizen's actions will be assessed in comparison to expectations of how a fair, honest, and reasonable person would act, rather than being decided based on the citizen's perception of the situation. Regarding the reasonableness of the force used to arrest someone, you only need to prove that you acted in a way you honestly and instinctively believed was necessary in the specific situation. The law does not expect you to be able to make fine judgments in the heat of the moment. Let's take a look at the power of the police to arrest in the UK. Basically, that power can be distilled into 3 lines. 1. Can arrest anyone anywhere and at any time. Can use reasonable force to effect the arrest. Can search the person being arrested. Now let's see what Section 24 of the Police and Criminal Evidence Act has to say. A constable may arrest without a warrant anyone who is about to commit an offense, anyone who is in the act of committing an offense, anyone whom he has reasonable grounds for suspecting to be about to commit an offense. Anyone whom he has reasonable grounds for suspecting to be committing an offense. If a constable has reasonable grounds for suspecting that an offense has been committed, he may arrest without a warrant anyone whom he has reasonable grounds to suspect of being guilty of it. If an offense has been committed, a constable may arrest without a warrant anyone who is guilty of the offense, anyone whom he has reasonable grounds for suspecting to be guilty of it. But the power of summary arrest conferred by subsection 1, 2, and 3 is exercisable only if the constable has reasonable grounds for believing that, for any of the reasons mentioned in subsection 5, it is necessary to arrest the person in question. The reasons are: A. To enable the name of the person in question to be ascertained in the case where the constable does not know and cannot readily ascertain the person's name, or has reasonable grounds for doubting whether a name given by the person as his name is his real name. B. Correspondingly as regards the person's address. C. To prevent the person in question causing physical injury to himself or any other person suffering physical injury, causing loss or damage to property, committing an offense against public decency subject to subsection 6, or causing an unlawful obstruction of the highway. D. To protect a child or other vulnerable person from the person in question. E. To allow the prompt and effective investigation of the offense or of the conduct of the person in question. F. To prevent any prosecution for the offense from being hindered by the disappearance of the person in question. Subsection 5C4 applies when any members of the public going about their normal business cannot reasonably be expected to avoid the person in question. Let's take a look at the powers of citizens' arrests. Section 24A of the Police and Criminal Evidence Act states, subsection 1, a person other than a constable may arrest without a warrant: A. Anyone who is in the act of committing an indictable offense. B. Anyone whom he has reasonable grounds for suspecting to be committing an indictable offense. Subsection 2. Where an indictable offense has been committed, a person other than a constable may arrest without a warrant: A. Anyone who is guilty of the offense. B. Anyone whom he has reasonable grounds for suspecting to be guilty of it. Subsection 3. But the power of summary arrest conferred by subsection 1 and 2 is exercisable only if the person making the arrest has reasonable grounds for believing that, for any of the reasons mentioned in subsection 4, it is necessary to arrest the person in question, and B. It appears to the person making the arrest that it is not reasonably practical for a constable to make it instead. Subsection 4. The reasons are to prevent the person in question: A. Causing physical injury to himself or any other person, suffering physical injury, C. Causing loss of or damage to property, or D. Making out before a constable can assume responsibility for him. Nigeria continues to borrow heavily from the British. The British judicial precedents we are about to consider are still relevant to the Nigerian context. How do the courts view arrests? How do the courts define arrests? Two cases, Sadiq vs. the State in 1982 case and Holgate Mohammed vs. Duke in 1984 case, will help us to see arrest with the mind and eye of the judicial system. Consider the facts in Sadiq vs. the State. The facts involved an invitation of an accused to the police station for questioning over suspicion of the commission of an offense. Initially, the accused didn't accept to follow the police officers to the station, but did when more officers were detailed to accompany her. This led to her being charged with resisting arrest and conviction at the trial court. However, the conviction was overturned on appeal. It was held that mere words unaccompanied by restraint cannot constitute arrest. Hence, on hearing an appeal against conviction, it was held that since no arrests could be said to have taken place, the charge of resisting arrests cannot stand. So what is the import of the court's holding in this case? An arrest can be effected without physical restraint if there is 1. Submission to custody by word. 2. Submission to custody by conduct. But if there is no such, then touching or confinement can be utilized to effect the arrest. Now consider the facts and decision of the second case, Holgate Mohammed vs. Duke. A police officer had purported to arrest the plaintiff, suspecting her of theft. After interview, she was released several hours later without charge. She sought damages alleging wrongful arrest. The issue for determination was put this way: was it a matter Detective Offin should have excluded from his consideration as irrelevant to the exercise of his statutory power of arrest? That there was a greater likelihood, as he believed, that Mrs. Holgate Mohammed would respond truthfully to questions about her connection with or knowledge of the burglary if she were questioned under arrest at the police station than if, without arresting her, questions were put to her by Detective Constable Offin at her own home, from which she could peremptorily order him to depart at any moment. The trial judge had found that he had reasonable grounds for suspicion and that the period of detention was not excessive. However, the use of an arrest to place her under pressure was improper. On appeal, the chief constable succeeded, the court saying that the question was whether the decision to arrest was willfully unreasonable, was it made in good faith, and did it take into account any irrelevant factors. Held that the idea that a suspect might more readily confess at a police station under arrest was a proper consideration, and given the reasonable cause for suspicion, the arrest was lawful. On appeal, Lord Diplock discussed the compromise which the law had by that stage evolved for the accommodation of the two rival public interests of the liberty of the subject and bringing criminals to justice. Lord Diplock's holding in that case laid down the common law principle with respect to what amounts to an arrest when he said, first, it should be noted that arrest is a continuing act. It starts with the arrestor taking a person into his custody, either by action or by words, restraining him from moving anywhere beyond the arrestor's control, and it continues until the persons who are arrested is either released from custody or remanded in custody by a judicial act. The mere act of taking a person into custody does not constitute arrest unless the person knows, 1, either at the time when he is taken into custody, or 2, as soon thereafter as it is reasonably practical to inform him upon what charge or on suspicion of what crime he is being arrested. Having considered the judicial position, we shall now move on to the statutory position of the law in the UK as of today. The test at common law was, is there reasonable and probable cause to suspect someone is guilty of a felony? If yes, then a police officer can lawfully arrest. The common law test above was given statutory force by Section 2, Subsection 4 of the Criminal Law Act of 1967. That section gave the police power to arrest anyone whom he, with reasonable cause, suspects to be guilty of the offense. The current statutory tests, as contained in Section 24, Subsection 6 of the Police and Criminal Evidence Act 1984, is to the effect that the police have the power to arrest if they have reasonable grounds for suspecting.